I'm rising on a point of privilege. As a member of parliament, and parliament as an institution, we have, in support of our work, people who are recruited to give the best technical support that they have and they can to this parliament to function properly. That includes supporting me as a member of parliament, whether on research or any guidance that is required. I am concerned, and deeply as such, by, I'm going to use about 4 words to describe, and I request that members bear with me. The demotivation amongst the staff within parliament, the incompetence, if I may, among the technical staff at parliament, the sabotage coming from the technical wing of parliament that impedes the ability of this parliament and us as MPs to do our work. I'll refer you, if you look at the quality of the reports that are coming up, sometimes we have had issues. Just reports, you'll find a problem. And you wonder, who are these technical officers who make these reports? If you go to offices, you find people who seem not even to understand their roles within this parliament. The last example I want to give that borders either sabotage or incompetence. When you, the Right Honorable Speaker, and the Right Honorable Speaker of Parliament, and you, the Deputy, was faced with a question of how to proceed on the censure motion of the 4 commissioners, you sought technical guidance from our technical people here in Parliament, either because of laziness, incompetence, sabotage. All they could do was to go and open the Black Laws Dictionary, and they landed on a word called res judicata, and they put in writing. And then they said, go and tell Parliament that this matter is res judicata. Mr. Speaker, if you look anywhere in the world, there is no scholarly work, there is no judicial interpretation, there is no publication that says the doctrine of res judicata is available to Parliament. The senior lawyers are here. Even in your first semester at law school, you will be told it is a doctrine exclusively available to the courts of law. In which circumstances? Where they are sued. Even when it goes to court, court must try it. A judge cannot sit and say on the face of it, this matter is res judicata. It must be pleaded by both parties and its evidence adduced to show. And then in the end, you make that decision. How can then the technical people in this parliament put the entire reputation of parliament, your reputation as the speaker, the Right Honorable Speaker, and even senior lawyers here, including the Attorney General on this side, that a matter that should come on the floor, just go and use a Latin word, res judicata. And we all sit here and accept. Is that not sabotage? And I have lawyers here who are more senior than me who can come and explain. That doctrine cannot be invoked in this parliament as a bar to any process that comes here. In any case, even if it were to be provoked, it is under Section 6 of the Civil Procedure Act. And all the ingredients are laid there. The parties must have been the same, and they must have gone to a court before. In this case, the movers of the censure motion, including myself, who signed number 1, I was not a party to that court. Secondly, it is exclusively available to only courts of law. A judge or a judicial officer sitting is the one can. That one did not happen. The subject matters must be the same. And there must be evidence adduced by the other opposite party to show that the matter has been tried and settled. This one did not happen. So my issue is it that the technical wing wants to show that this entire parliament is so incompetent that they just pick a Latin word and just put it there, and then we all accept and agree that now the matter is res judicata? Did we not go to school?
Thank you.
So, Mr. Speaker, my request, I will receive information, is for your good chair to vacate that decision. To vacate that decision, any other reason can be given. Any other reason can be given, but let Parliament look serious. Let our technical people help us. let our technical people show that this parliament is properly constituted. So I really kindly request from you. I will take the information.
Thank you, Honorable Odul, for giving way. The information I have, Right Honorable Speaker, it goes to the root of our motion. Indeed, it's true, in the said communication, I went and looked at it, where your chair ruled that the censure motion cannot proceed, indeed because of res judicata, that a matter had already been decided by a competent court of law, and now Parliament had turned itself into another court of law, which wasn't the case. Right, Honorable Speaker, Parliament is a house of record. It is very important that what is ruled today should be able to stand the test of time. For you to hide behind res judicata, which is totally inapplicable, totally, not anywhere, Mr. Speaker, and you sit in the honorable chair and you guide the 559 souls here, some very well learned, Right, Honorable Speaker. I find that that matter needs to be true, and I hope I hand.
Mr. Speaker, sir, my last point. One of the authorities, apart from the Civil Procedure Act that I referred you to, Section 7, Section 6, is the judgment by the very esteemed Honorable Justice of the High Court, Justice Stephen Mubiro. In a case he decided in Arua, I think it was Elizabeth Ozia or something like that versus Shaban somebody. I'll get a copy. It is extensive in discussing that doctrine. It is cited authorities at the level of the Court of Appeal, at the level of Supreme Court, well elaborated. I think we need to find a way of vacating that ruling and that decision so that this parliament is seen seriously. In fact, I pity the senior lawyers who are here, if we allow it to remain, including the head of the deputy head of the bar, the learned attorney general who are here, and seniors like the Honorable Segona, that this parliament can sit and accept. And even you, Mr. Speaker, from Makerere Law School, I must emphasize, that should not be allowed to stand. I thank you.
Thank you. Driving from Gulu to Kampala, I saw the debate, especially when my good friend Honorable Sechikubu brought a serious issue here about the same. Maybe you see something you don't know is that in my Luo accents, you don't have S. You will not have Z. Okay? You don't have X. So when a person from my sub-region say recharge, don't mind. Because we don't have S, we don't have H, we don't have the what? So that's okay. So when the matter was being discussed on the floor here, unfortunately, the presiding person is being disorganized. When the discussion was here, I was actually watching on my phone, and then what came very clearly is that you ruled on that day that this matter, whoever is not satisfied with it should go to court. I find we are just moving in the same circle. I read a book, Who Moved My Cheese? And some of you who have not read it, please take the opportunity to read it. There are issues which you should not be relying on the same issue all the time. Since you've ruled on this matter, are we proceeding well to again every time discussing the same issue here? I don't know about the procedure, right?
Thank you very much, Speaker. I have been, Right, Speaker, you did read a letter here. And I think it's important that we move at the same level. Right, Speaker, in the letter you read, incidentally, the courts were able to define both statements, sub judice and res judicata. Right, Speaker, I want to read the judgment of Muhammad Ali Bai that you cited in your letter, versus Attorney General, miscellaneous cause number 2017 of 2021. And this is what the judge said. In my view, while Parliament, I'm making reference to the letter, it's on record. You can read it. In my view, while Parliament and its relevant committee were vested with the constitutional right and mandate to investigate and inquire into the matters that are subject of the impugned report, their mandate does not extend to undertaking investigations into matters that are the subject of courts' proceedings and decisions. And this is what they said. If done, this contravenes the res judicata rule, where a matter is already determined, and the sub judice rule, where the matter is pending before the court. In this case, it should be noted that the subcommittee was operating as a quasi-judicial body, blah, blah, blah. So the Right, Speaker, I am just giving information that the same courts have already clarified res judicata, sub judice with regard to parliamentary proceedings.
Thank you. Now, honorable colleagues, let me make it very easy. Please.
He has gone on record, Right Honorable Speaker.
Honorable colleagues, please.
But he has gone on record.
Honorable colleagues, please. Honorable colleagues. Honorable colleagues, the Speaker is the one who has been asked. Not you, not any member here. So it's me to respond. Now, honorable colleagues, I want first to make it very clear that the Speaker made a ruling, and this ruling won't be vacated. If you're dissatisfied with the ruling of the presiding officer, of the Speaker, the rules of procedures are very clear on the procedure to do that. Number two, as leaders of the House, anything which we believe that contravenes the law and will condemn this House costs is an issue we shall not get involved into. In the case of Murangira, Justice Murangira versus Attorney General, as quoted in the letter, Parliament tried to bring all these arguments. It was condemned at huge costs, which were met by the taxpayer. That matter is closed. Procedure, Honorable Sechkubo, procedure.
Speaker, without going into what you've guided, we all know for you to raise sub judice, a matter must be active in court so that the debate of this House can either negatively or positively influence a decision of court. And that was done. There is no matter pending before courts of law. So that now we can say we are talking about sub judice. Number two, if you look at the judgment itself, it gave out points of entry, for instance, penalizing the clerk to Parliament. It gave out points of entry so that this Parliament can take stock of the ruling so that it can correct those areas which court found to be negative. Now, Right Honorable Speaker, At this stage, there is no way you are saying you are going to influence negatively a matter before court. Only it put it to your shoulders and the shoulders of this house. The clerk to this house has been condemned to be punished. And indeed, those are action points that must proceed from that judgment. And indeed, now we are saying, once you have taken stock of the ruling, it is now the right time to debate and see where did we go wrong. Who are those to be held accountable? And indeed, it is within the hands of this parliament to find the way forward. Who are condemned members. You sit in this house, but we are all condemned. And court castigated this house and castigated the leadership of this house. So do we fold our hands even on that point of law?
Thank you.
Lastly, from me, Right Honorable Speaker, how about other issues that do not even talk about service award? The fictitious trips. We talked about fictitious trips, which are different from the service award. And that was not part of the court.
Thank you, Honorable.
We talked about where this...
Thank you.
Where,
Now, Honorable Korik, very clear. Your own rules are clear that you cannot proceed on a matter the Speaker has ruled on. These are your own rules. These are your own rules. You can only do that if you want to challenge the ruling. No, Honorable, you don't point a finger to the presiding officer. No, that's... No, Honorable Linus, please go on your line. Honorable, your NRM, go to the side of NRM. Go to the side of NRM.
Definitely, I will not make reference to a matter where you have made a ruling, but I'm deeply concerned that while you maintain your ruling, some words have been used against our staff, who are professional staff. Words like incompetence, words like sabotage, which in my humble opinion do not go down well and demoralize people who serve us, but also the confidence of the people that we serve. I thank my brother, the Honorable Jonathan Odul, because first he raised them at a matter of privilege, but stated, actually apologized to us that he was about to use them. Now that you have maintained your stand in your statement, is it not procedure right that you find a way of doing away with those words against our staff?
Number one, a Speaker of Parliament is not someone whom you think will just receive a statement from a staff and just append a signature. No. We consult, but the final document that is signed is our document. It's not a document of the staff. In your opinion, you can call us incompetent. You can abuse us. Yes, you can. You know, words don't kill. Hey, words don't kill. Me calling me anything, you get it. I lose nothing. I've not seen myself losing a kilogram. Sometimes I add on kilos. So I don't mind being abused and all that. But I want to defend our staff. And thank you, Honorable, for raising it. Our staff have been appraised. Our staff, we've just finished the review of our strategic plan. Our staff have ensured that the committees deliver on their mandate. We have processed all our bills. We have processed our budget. I have seen reports from the committees on accountability. Colleagues, you've been here praising the reports coming from the committees of Parliament. Our staff are very competent. Our staff are very competent, okay? and we are proud of them as the leadership of Parliament. In your opinion, if you disagree with our staff, in your opinion, if you disagree with our staff, okay? This is your opinion, but it can't go on the record of this House that our staff are incompetent. Yes, Honorable Jonathan, you can clarify if you want to.
I used deliberately, and this is my clarification, about 4 words. I said it borders incompetence. I said it borders sabotage. It borders demotivation. And these are my reasons. For a staff of Parliament to be competent, they must have passed through the competency test. That is, they have been invited through a transparent process to apply for a job. That they are shortlisted and they have competed and they have emerged the best. Mr. Speaker, I would like to put it on record here that we have not had the opportunity for the members of the public, the best of the best in Uganda, to compete for jobs in this parliament. And therefore, it cannot be said that people who have been picked on the basis of being a friend, a relative, and an in-law, that comes to this house and they are protected, can be said. I would kindly therefore ask that going forward, Mr. Speaker, I will give you information, but let me clarify. So, all I am saying,
Honorable colleagues, let's listen to our honorable colleague.
So, Mr. Speaker, I used this because, one, I am aware. I am aware. I am aware, and I'm going to invite submissions from professional human resource people who are members here. We have in this parliament senior, very competent technical officers who are demotivated and are not willing to do work now because positions that they should be able to serve as have been dished out in ways that do not match the public service standing orders. It is happening here. Very resourceful persons that this government has invested in building their capacity. Others have even worked over 20 years. They are reading newspapers in this house. They are just reading newspapers in this parliament. They don't have work to do because they have handpicked people who, some of them were even in secondary school. Some of them even did internship in this parliament. And the people who supervise them, they bring them and now they are their bosses. Do you expect such a public servant to do the work? That's what I am saying. So I'm inviting you.
Thank you.
I'm inviting you, Mr. Speaker, to salvage the situation in this parliament. You cannot have resourceful people being wasted, and when we have trained them, in exchange for people who are just going to walk in, they don't know what to do. I'm inviting you to reflect together with the commissioners, to look at...
Thank you, Honorable colleague. Thank you. Thank you. No, please, no. You know, in our culture we say, even when you're beating a snake, that you leave it some space. Okay? Yeah. So, I hope you understand me. So even when you're testing my patience, you should leave some space of knowing I'm a human being. Okay? Thank you. So, I think, Honorable Seguno, the clarification brought by Honorable, by Honorable Odur, however much I appreciate it, but it puts our staff in a bad light. In that, Honorable Odur, staff can interact with you anytime. And even members, you can't satisfy all. Okay? These staff have their own channels. Because when you look into this parliament, I think the new staff are like 10%. And not more than 10%. So if you say that the new ones are the ones stopping Among the people, for example, who are directors, I don't think there is any new director who has been recruited. These are staff who have been here. And at our level, these are the people we deal with. We don't deal with the junior officers down there. But whatever decision is made in Parliament, we own it as leadership. So kindly don't put it on staff. Put it on the Speaker, put it on the Deputy Speaker, put it on the Commission. We own it, okay? So, in case one has judged our decision is to be incompetent, well, we shall incompetently read you for some time until 2026. Yeah. If one is considering us incompetent, if we are incompetent, unfortunately, you're with us up to 2026. Yeah. Okay. No, Sewungu, no. Honorable Sewungu, no, please. We shall competently read you until 2026. Honorable Sewungu wanted that. But you see, it depends on how, whatever I'm doing, if you look at it from an angle of being incompetent. What? Yes. What do I do to you? Honorable Minister for National Guard, I wanted to close this issue. Okay?
When we were drafting the rules of procedure, we were very deliberate to protect. Parliament was intentional to protect the office and the chair of the Speaker. That we knew sometimes a Speaker may make a ruling, you may be happy with it, you may not be happy with it. But we provided that we shall not just casually satisfied with the decision by the Speaker, how you can appeal it. So isn't it procedurally incorrect for us to spend an hour on a rule which we wrote ourselves, that if you are not satisfied with the ruling of the Speaker, there is a method you use to challenge it. It is because I am the MP for Chinchiz East, and I am elected to speak here.
Thank
I
you.
was
From your seat all the time, come to the microphone, kindly. I request you, kindly. Because you're a senior legislator, listen, you're a senior legislator, let's go on the rules, please. Honorable colleagues, let me make it very clear. It's against our rules of procedure to proceed on a matter the presiding officer has ruled upon. And if you want challenge, like Honorable Jomun said, that matter, you can challenge it within our rules. Next item.